Alright, Maine Legislator, Titles 38, Water Navigation, Chapter 3, Protection of the Improvement of the Water, Subchapter 2A, Oil Discharge Prevention, Pollution Control. Finding purpose of the legislature, finding that the clear by the highest and the best, for the sea coast of the state, by the source of the public, private, the recreation, soulless, for the pressure of the industrial society, by the source of the public, private, the commence of the fishing, lobstering, gathering, other marine life, the use of the food production, other commercial activities. Legislature further finding that the clear for the preservation of the use of the merit of the highest urgency, private, the only uses served effectively to maintain the coastal oil of the usual, the tile, the last beach of the public lands adjoining the sea coast of the coast, through the pristine condition of the possible taking in action account with a multiple use accommodation as to provide the broadest possible the promotion of public and private interest with the least of the possible the conflicts of the scope of the diverse use. Legislature further finding that declare that the transfer of oil of the petroleum product and their byproducts between the vessel and vessels on shore, the vessel with the jurisdiction of the state water of transportation over the handling on inland area of the state hazardous undertaking with the spill of the discharge of the escape of the petroleum products and their product and their byproducts occurring as a result of the procedure involved with the transfer, storage, other handling of the product with the greater danger of the damage of the marine, estuarine, and surface water adjacent to the terrestrial environmental state to the ownership of the shorefront property, public and private, the recreation, citizens of the state, and other interests deriving livelihood of the marine and inland surface waters related activities. The beauty of the Maine coast and inland waters, such hazards that frequently occur within the path occurring now and the present future threats of the potential catastrophic proportions all explained, especially declared with the municipal with the paramount interest of the state for the set forth the subject for the state, such state the interests outweigh the economic burdens imposed over the legislator promptly engaged, transferring the other handling oil, petroleum products with their byproducts for the related activities. Legislator intended the enactment of the legislation extra of the police power of the state with the review of the Department of Environmental Protection with the conferring of the upon the Department of Power to deal with the hazard of the threats of the dangerous damage to power opposed to the transfer of related activities, require prompt containment of the removal of the pollution occasion thereby with the provide procedure for the whereby the person suffering the damage of the occurrence of the may be promptly made whole with the established fund with the provide with the inspection supervision of those activities guaranteed with the prompt payment reasonable damage claims the resulting therefrom. Legislature further finds it clear with the preservation of public use of the referred to in subject for the grave public interest for the concern of the state with the promoting general welfare, preventing the disease, promoting health, providing with the public safety. State interest of such preservation outweighs any burdens of absolute liability imposed with the legislator upon who's engaged in transferring the other handling of oil, petroleum products, and their byproducts and related activities. Our definition of the following word of the phrase subject of the unless with a different meaning with a plainly required for the context of the following meaning with a barrel means of the 42 gallons of US 60 degrees Fahrenheit board coast 382 coastal water that means all of the boards stay with the rise and fall of the tide of the distance of 12 miles of the coastline stay with it does not include any area above any fishway with the dam with the fishway with the dam and the dividing lines between the tidal water and fresh water. Discharge means an expelling, leaking, pumping, and pouring, and emitting, and escaping, and emptying, and dumping for a federal contingency plan. Federal contingency plan for the area of the region of the local contingency plan for the oil spill response with the prayer published by the President of the United States under the Federal Water Pollution Act Control Act of the 33 United States Code Section 1321 is amended. 4B facility closure means a removal of the oil of the oil residential of the tank for the related appurtenancies, decontamination of the tank for the related appurtenancies, removal of the tank for the related appurtenancies, disconnection, removal of the underground pipe to secure capping or plugging underground piping with which removal is not feasible, and E, any other step required with the safety decommission facility remedy the sediments of the soil, the groundwater, surface water, support of the surface of the facility site with the determine the department and suitable for the residential use that meet the most protective use standard practicable by the facility site. Fund means the Maine ground surface water cleanup response fund. National contingency plan means the national contingency plan for the oil spill response prepared with the published by the President of the United States with the Federal Water Pollution Control Act of the Title 33 U.S. Area Code 1321 is amended. Oil means oil additive of the petroleum product with their byproducts of any of the kind with any other form that include but not limited petroleum fuel, oil sludge, oil refuse, mixed oil of their waste, liquid asphalt, bunker fuel, crude oils, all other liquid hydrocarbons regardless of the specific gravity. Oil does not include liquid natural gas. Oil spill response activity means assistance with the mitigation, attempting to mitigate the effects of the actual threat and discharge oil prohibited in Section 543. The term that includes lightering oil from the disabled threatened vessel with the action preventing, containing, cleanup, or the removal, the disposal of the prohibited oil discharge. Oil term facility or facility, oil terminal facility means the facility with the in-kind with related to pollutants located under the surface of the land or any of the water includes submerged lands for the use capable of being used for the purpose of the transferring process of the refining oil for the purpose of the storing of the same with the business include the facility under used for the capable of being used to store no more than 1,500 barrels of 63,000 gallons. Any of the facilities not engaged in the transfer of the oil from the waters of the state, a vessel considered an oil terminal facility only in the event of the ship to ship the transfer of the oil, but only the vessel going to and coming from the place of the ship to ship the transfer of the permanent fixed oil to the terminal facility. The term does not include the vessel engaged in the oil spill response activities. Owner and operator of it means any person owning and operating with an oil terminal facility with the lease for the contract with any of the form of agreement, the person with the control of the head with the responsibility of the daily operation of the oil storage facility, person shall be with a national person, firm, an association, partnership, corporation, trust, state with the main agency thereof, with the governmental entity, with the quasi-governmental entity, with the United States of America, with the agency thereof, with any other legal entity. Responder means any of the person who provides assistance, advises the mitigation, attempting to mitigate the effects of the actual threat and discharge of the oil provided and prohibited in Section 543. Preventing clean up of the remove of the disposing with the attempt to prevent the contain clean up of the remove of the dispose of the discharge for oil prohibited in Section 543, except for any of the person who the otherwise responsible for the actual threat and discharge for the first instance. State marine oil spill contingency means the contingency plan for the oil spill response prepared for the commissioner according for the subchapter of the responsible party means any person who could be held liable under Section 552 with the defined Section 562A subsection 17 related to prudency with the purpose of the valve pumps, valve pipings with the loaded racks, secondary containment to determine the department any other further structures related to the operation of the oil terminal city. Transfer that should include both onload and offloading between the terminal and vessel to terminal and vessel to vessel, underground oil storage facility, and vessel include every description of the watercraft with other contraventions used and capable of being used as a means of the transportation over the water, self-propelled, otherwise shall include barges and tugs. Alright, 543, pollution and corruption of the water lanes of the state, prohibit the discharge of oil onto and upon with the coastal waters, estuary, tidal flatlands, beach with the lands adjoining with the sea coast of the state, into and upon with the lake of the pond, with the river, the stream, and the sewer, with the surface of water drain, with the groundwater of the other states of the state, or public over the private water supply with the other lands adjacent to and any other surface of the state is prohibited. Nothing would stand with the prohibition in this section of the department made license the discharge of the waste or refuse the effluent with the include with the natural damage, drainage contaminated owned by oil into upon with any coastal water if and only it finds the discharge will receive the be at best available the treatment. The discharge will not degrade the existing water quality perceptibly, violate with the classification receiving the waters or create any visible sheen upon with the receiving the water. License is not required and a person may not consider violation of the section discharge oil to surface waters if the discharge occurs in the process of recovering, containing, cleaning up, the removing oil spill with the surface of waters undertaken with complying with the instruction of the commission with the commissioner's designee, and acting upon the application of such any license the department shall file with the provisions of subchapter 1 so far as they are applicable. 544, powers and duties of the board. Powers of the duties of the conferred with the subchapter of the exercise of the department and shall be deemed essential for the governmental function, the exercise of the police for the power of state. 1. Jurisdiction of the right of the power of the duty of the conferred with the department. Now, the person of the subchapter extend with the distance of the 12 miles from the coastal line of the state with the license of the required of the subchapter shall be secured with the department and subject to the terms of the conditions set forth in the subchapter. 545. Operation without a license prohibited. No person shall operate with be operated with a oil terminal facility defined in subchapter without a license. Expiration with the license is issued upon application after the period of not less than 12 months of no later than 60 months after the date of the issue. The department may issue the temporary license short period of time and defined with the applicant subsequent substantially comply with the file has failed to comply with one more provisions existing with license or the issue with the subject of the term such term with the condition by the department necessary to carry out the purpose of the subchapter the renewal of the license the condition with the president of the issue with the renewal of the license of the department shall require satisfactory evident application of the process of implementing shape of the federal plan with the regulation of control of the pollution and with the related to the abatement and thereof the discharge occurs. Exemption of legislative from the declared with the likelihood of the sufficient damage to the marine, estuary, and the terrestrial environment due to spill of the petroleum product of their byproducts by the following class of the persons of the remote, the due with the limited nature of their operation of the small quantity store according exempt of the from the state of the licensing requirement that imposed on this section. Person engaged in the business servicing the fuel requirements of the pleasure craft, of the fishing boat, of the other commercial vessel, of the purchase of the consumer, are the same at neither the service of the vessel with 200 feet over length is or less overall length. Certain vessels include licenses issued with any fixed with a permanent oil terminal facility must include the vessels under the direction control of such facility with the use of the transport over the such fixed permanent facility. Vessels within the state water with the person of the operating with the cover of the operator of the vessel with the use of the transport or between a permanent and fixed oil term facility with the vessels with state waters, which vessels is not subject to the direction control of the permanent oil with the terminal facility shall obtain the license required by this section. Subsection does not apply with the vessels engaged in oil spill response activities. 545A, underground oil storage facilities repealed. 545B, registration and transportation of oil inland areas. Effective October 1st, 1988, any person with the transfer of the rail or highway more than 25 barrels of oil in the Maine into Maine any one time, regardless annually of the must register annually with the commissioner. Alright, 546, regular powers of the department. Proceed with adopting the rules regulation, emergency rules regulation without hearing enforcement rules of the regulation, extent of the regulatory power of the department shall adopt the rules included but not limited to the rule of governing in the following manners: operating with the inspection with the requirement of the facility with the vessel with the personnel with the other matters relating with the license operations subchapter include with the annual inspection of the eligible terminal facility, secure the method of reporting discharge for the occurrence prohibited to the subchapter, the procedure methods made with the equivalent of the use by the person subject to the regulation of the subchapter, procedure for the methods made committed to be the removal of the oil, petroleum pollutants, to the development of the implementation criteria plan meet with the oil, petroleum pollution occurrence of the various degree of the kind with the include of the shape of the marine oil contingency plan plate required under the section 546A. Those plans must include the provisions of the annual drill, sometimes unannounced, with the determined adequacy of the response plan with the preparedness of the response teams, with the establishing liability insurance for liabilities under section 552 with the development of the implementation criteria plan, cleaning of the store, carrying of the facility. This is out of service but not subject to the facility closure requirements under 552B. Development and implementation criteria plans facility closure and required in section 552B include the standard of the procedure of the reporting requirements of the removal of the tanks from related to the permanency remediation facility site. E4 with the standard of the establishing financial ability with the adequate with the guarantee of the performance of the license obligation under section 552B with the establishment of the time of the control of the districts. Compromising section of the main code with establishing rules of the particular requirement of each of the district. Requiring G with the requirements of safety operation of the vessel, barge, tugs, motor vehicle with the motors, equipment, operating relating use of the operation terminal facility, the refinery, of the approach of the department of the terminal facility of the refineries, H such of the rule of the extension of any of the condition of the may require that is reasonable and necessary for the carry out of the intent of the subchapter. I and J, K, with the operation of the inspection requirement of the interstate with the interstate pipelines, with the excluding natural gas and artificial gas pipelines. 5. Facility response plan. Every facility subject to the license under the section shall have the file of the department of the copy with an oil discharge response lines from the President of the United States under the Federal Oil Pollution Act of 1990, Public Law 101-380, with section 4202 with the 104 statute 484 with the statement of the plan is not required by federal law. Vessel response plan. Every tank of the vessel with the defined is under Title 46, United States Code Section 2101. Interstate waters have available the inspection with the measure and agent with the commissioner copy with the oil discharge plan with the required with the under submitted with the President of the United States with the Federal Oil Pollution Act of 1990, Public Law 101-380, section 4202 with the 104 statute 484. Alright, 546A, the State Marine Oil State Contingency Plan. Plan by the Commissioner shall divide December 31st, 1991, a preliminary state with the Marine Oil State Spill Contingency Plan. Commissioner shall hold the public hearing with the process of developing the plan, but the Commissioner shall consult with the coordinate with the agency with the organization to develop the information oil spill respond with the plan to prevent duplication after the creation of the incompatible data with the databases. 2. Worst case scenario of the Marine Oil Spill Contingency Plan with the drift of the rain system with the included spills of 100,000 gallons and 1 million gallons and 6 million gallons of the worst case scenario with the major part of the major port area with both favorable and diverse condition. Worst case scenario within each major port with the loss of the entire vessel with the following capabilities: port land with 30 million gallons, Pensacola Bay with the Pensacola River, 11 million gallons. Portsmouth, New Hampshire, 13 million gallons. St. John, New Brunswick, 90 million gallons. Esport, 100,000 gallons. Elsewhere, any on the coast, 30,000 gallons. Contents of the plan, the marine oil spill contingency plan include designation of state with the oil spill, coordinated with a clear definition of the role of the Department of Oil Industry spill response to the organization of the United States Coast Guard and various circumstances involved with the role of the other state agencies, including the Maine Emergency Management Agency, clear definition of the state of the role under the joint agreement of the United States and Canada as in can U.S. land. Inventory of the spill response with equipment available to the state with a listing of the source of the qualified trained spill with a response with the state with a pre-approved with the criteria with the dispersal of bioremediations in suit burning developed with the consolation of the United States Coast Guard of the reasonable agency with the name of the individuals authorized to make with the final decision with the state on their use and identification sensitive of the area of the resource of the management strategy to protect them, identification of the resource of the wildlife rehabilitation, with identification of the facility with the disposal of the oil debris with the separation, transport, storage of the recovered oil. For consideration, preparing the plan with the pre-post position response team with additional equipment that must be considered with the provision. The commissioner shall at least annually review and make recommendations to revise the plan. It shall note all licensed industrial parties required with the notified and substantial change of the plan. Licensed and interested parties may request public hearing changes of the plan subject to written request with the commissioner signed with at least 5 persons. Alright, 546B, the strength of the area identification protection. Since of the area identification of data management with the Commissioner with the Constellation with the Department of Marine Resources, with the Department of Inland Fishery Wildlife, with the Department of Agricultural Conservation and Forestry, with the United States Fish Wildlife Service, with the appropriate agency for the organization, both public and private shall assess the nature of the extent of the sense of the area of the reach of the marine environment threatened by the oil spill, to develop the system with the collect with the maintain is necessary the data of the commissioner shall ensure the duplication effort among the agency of the creation and incompatible data of the databases are minimized. 2. Protection priorities. 3. Use of state geographical inventory information systems with the development of the pursuit with the subsection 1 must be based with the state with the geographical information system to the maximum extent factor with the permission for the responsible design, implementation, execution of the marine oils prevention plan response system. Commissioner will specify the format, the type of the data to comply with the other agencies, the money to supply with the fund with the format of the digital conversion of the data must comply with the standards developed with the state geographical information system. The data must be added to the system database state geographical information system that must provide with the technical assistance of the final repository of the final geographical information system data of any of the person employed with the area mapping support with the bottom money fund must be involved with the digitization quality assurance with the control of the training with the sense of the area map to develop must proceed 3 phases as follow. Pilot project with the Costco Bay was completed with December 31st, 1991. Pensacola River and Pensacola Bay area completed in 1992. Remainder of the coastline completed in 1993. 546C, Wildlife Rehabilitation Plan. With the Wildlife Rehabilitation, the Department of Inland Fishery with the Wildlife Consult with the Department of Environmental Protection, the Department of Maine Resources with the Department of Agricultural Conservation and Forestry with the United States Fishery with the Wildlife with the Department of the Agency, the organization developed a plan with a rehabilitation oil spill damaged wildlife resources. This plan includes policy priorities for the guidelines I draft for the Rehabilitation Act, the annual list of the cost effective of the wild rehabilitation act for the mechanism for the youth of volunteer with the due regard of the safety, the identification of the need of the reach of the facility for the rehabilitation act for the inventory of those available. Preliminary agreements, treatment centers of the centers and facility, the recommendation and implementation plan with the required training efforts. 547, emergency proclamation of the governor's power. With any of the disaster catastrophe exists in the period of the imminent rising of the discharge of the oil, the governor shall proclaim to declare the fact that the emergency exists with all sections of the state of the governor temporarily absent of the state, otherwise unavailable. The next person of the state that would act with the governor of the office of the governor would be vacant. Shall the proclaim to declare the fact that the emergency exists in all of the sections of the state. With a copy of the proclamation must be filed with the secretary of the state of the governor. Shall have general direction the control of the department and shall be responsible for the carrying out of the purposes of subchapter. In the event of the oil spill emergency, the commissioner shall represent the governor in all the direct abatement and cleanup of the resource of the Protection Act with the coordinated with the federal industrial other state of the response teams according to the title 37B, section 742, subsection 3, performing the duties subject of the governor is authorized directed to cooperate with the department's agency with the federal government, with the office of the agency, with the state, with the foreign government, country, with the political subdivision thereof, with the private agency, with the matter of the pertaining to the disaster, catastrophe, with the performance of the duty of the subchapter, the governor is further authorized and empowered to orders of the rules regulation to make an amendment with the assignment of the necessary order of the rules regulation carried with the subchapter the limit of the authority conferred with the governor and not within consists of the rules regulation directive of the President of the United States, with the federal department and any other agencies having specialized authorized emergency functions. 2. Delegation of the authority. Delegated authority vested with the governor and subchapter to provide sub-delegation of the authority whenever the governor is satisfied with the emergency no longer as if the governor shall terminate with the proclamation of any other proclamation affecting section of the state covered with the original proclamation, any of the part thereof of the publication published in a newspaper the state of such posted place of the governor in person acting with the capacity considered appropriate. Emergency management provisions, Title 37B, Chapter 13 apply with the eminent domain compensation, mutual aid, immunity aid, the emergency right of way, the enforcement compensation apply with the disaster catastrophes proclaimed by the government under this chapter. Alright, removal of prohibited discharge. With any person discharged and suffering with a discharge, all of the manner prohibited in Section 543 shall be admitted will undertake with the removal of the discharge. The Commissioner of Satisfaction, notwithstanding the above the requirement of the Commissioner, may undertake with the removal of the cleanup of the discharge, that may retain the agent's contract for the purpose of the wish shall operate with the direction of the Commissioner. The Commissioner again may implement with the remedy to restore of the replace applies contaminated discharge of the prohibited in Section 543, included all of the discharge of the interstate with the pipeline for the most cost-effective alternative, the technology feasible, the reliable, effective, mitigate, with the minimize the damage, provide adequate protection over the public welfare and with the environment. The Commissioner may investigate with the sample site of the will of the discharge may have occurred, identify the source of the extent of the discharge during the course of the investigation. The Commissioner may require the submission of the information and documentation relate with the discharge under the investigation with the person of the Commissioner have the reason that may leave. May be of the responsible party for the Commissioner find for the after of the investigation of the discharge of the oil has occurred with the may create with the threat of the public health of the environment. The Commissioner may issue the cleanup in order within accordance with subsection 568 subsection 3 unexplained discharge oil of the state with the jurisdiction discharge oil of the occurring with the waters beyond with the state with the jurisdiction of any of the penetrate of the state. The jurisdiction must be removed with any of the direction of the Commissioner explained with the involved with the removal of the cleanup of the discharge including restoration water supply with contaminated by the discharge interstate pipelines or other discharge prohibited in Section 543, whereby the person reporting with the discharge of the Commissioner agent of the contractor must be paid in first instance of the main ground surface water cleanup of the response fund with any reimbursement due to the funds must be collected in accordance with Section 551. If the water supply well was installed after October 1st, 1994, served at the location immediately before the installation was served with a viable community public water system wells, or it becomes contaminated with the oil, or delineated contaminated with the Commissioner of the person responsible for the discharge of the oil, will not obligated the subchapter to reimburse any of the person expense for the treatment of replacing the well was installed with the delineated with the department as contained within it as a result of the proximity of the area with the hazard water storage treatment of the disposal facility with the license by the department that uncontrolled hazardous state with the defined Section 1362, subsection 3, listed within the department. Oil terminal facility defined in Section 542, for the subsection 7, the license of the department, the solid waste with the disposal facility with the defined Section 1303C, subsection 30, the license for the department and or enclosed with the abandoned municipal solid waste landfill listed with the department. 2. Areas not delineated, the wells installed within any of the area on the described the subsection 1 of the obligation of the subchapter of the Commissioner and any of the person responsible for the discharge of the oil with regard to the placement of the treatment of the wells limited to the reimbursement of the expense of the installing of the well for the property or abandonment of the well owner with the responsible in such a case for the expense of the replacing treatment of the water supply well with the including cost of any of the pumping, piping installed with the well for this purpose of a section of the viable community public water system of the community water system defined in Title 22, Section 2660B that has not indicated intent with imminently ceasing providing with the water to the location. Alright, 549, personnel with equipment, the Commissioner may shovel the maintain the shelf of the porch of the state with the other place for the Commissioner with the determined employee with the equipment necessary with the carry over the subject of the Commissioner with the subject of the civil service law may employ the personnel necessary with the carry over the purpose of the subject of the prescribed the duties of the employee with the salaries of the employee with the cost of the equipment that must be paid for the marine gown, service water, clean up the response fund, the establishment of the subchapter. The Commissioner of the Director of the Division of the Geology, Natural Area of the Coastal Resource shall periodically consult with the other relative of the proceed to prevent the old discharge of the coastal water state with the other offshore of the drilling production facility with the inspection enforcement employed with the Department of the Line of the duty subchapter to have the power of constable. 550, enforcement any of the person who caused the responsible for the discharge of the violation. Section 540, 59, subject to any of the files, find civil penalty with the person with the report, remove the reports within 2 hours, promptly remove the discharge in accordance with the rules and the orders of the Board of the Commissioner, reimburse the Department any of the disbursement found with the connection with the discharge pursuant to Section 551, subsection 5, subparagraph B, within 30 days of the demand. 551A for the Maine ground surface water cleanup fund, the responsible if it is established with the Department of the non-lapsing revolving fund with the carryover the purpose of the subject of the balances fund of the limited to $18.5 million. The Department of Environmental Protection collects fees in accordance with subsection 4 of the fund of the creator license, the registration of the fees for the late with the payment of the fee with the registered plan with the transfer of the fees, reimbursement of the fee for the charge of the relief of the subchapter 2B for the fund for the charge for all expenses of the department of the relief of the subchapter include the administrative expense for the cost of the removal of the discharge of pollutant and the third-party damage for the cost of the cleanup of the shore, oil and oil byproducts, including but not limited to the restoration water supply for the obligation of the state with pursuant to Title 10, Section 1024, subsection 1. Money in the fund that need currently for the maybe obligation of the department that extra for the responsibility under subchapter that may be the deposit of the treasurer or the state of the credit for the fund that may be the invest for the source of the band and provide for the statute of the interest of the receiver that invest must be created to the fund. Research and development is sensitive to the area of the data management mapping. Research and development, the legislator may allocate no more than $100,000 annual amounts. Currently, the fund is devoted for the research and development causes affects removal of the pollution caused by the oil and water state with the subject allocation made in accordance with Section 555. 2. Third-party damage for the person claiming to suffer the property for the name of the actual economic damage if it's not limited to the loss of the income of the medical expense derived with the physical body of the injury to directly and indirectly result of the discharge of oil prohibited in Section 543. Include all discharge of the oil from the interstate with the pipeline subsection with the call of the claimant with the must supply within 12 months of the occurrence of the discharge of the coastal wall for the other discharge within 2 years after the occurrence of the discovery of the injury or the damage, whichever the date is later. Commissioner stating with the amount of the damage alleged to be suffered with the result of the discharge of the commissioner prescribed the appropriate form for the detail for the application for the commissioner may contract for the assurance for the professional for the claim process claim of the commissioner may upon with the petition with a good cause shown with the limit type of limitation filing damage claim with all 30 party damages claim with no determination of war that has been made must be processed in accordance with substance of the procedural provisions of this section. Or when a responsible party known with the commissioner shall stand with a certified mail with the responsible party known claim of the written over the third party joint party damage claims of the process of the interested party of the responsible party shall provide with the written notification of the department with the responsible party. Intent to join within 10 working day with the receiver, the note of the report, responsible party join with an interest to provide the formally agree with the written with the amount with the damage claim with the determined amount with the claim with abiding with the subsequent action with the reimbursement with the fund with the claimant that has not been compensated with the third party damage of the reasonable part of the expense of the above the responsible party with the deductible claimant, reasonable party with the commissioner of the agree with the have the amount with the damage claim with the reasonable party that does not join interested party with the responsible party is known if the after the commissioner has extra with the reasonable effort for the certain with the responsible party with the claimant and commissioner of the agree with the amount with the damage of the commissioner so certified with the amount of the claim and the claimant in the treasurer state with the treasury of the state that shall pay the amount of the claim from the fund. If the claimant is responsible party and the commissioner is not able to agree with the amount of the damage claim, the responsible party does not join an interested party when the responsibility is not known after the commissioner has exercised the reasonable effort to assert with the reasonable party the claimant with the commissioner are not agreeable to the amount of the damage claim with the claimant is subsection 3A. Third party damage must be stated in their entirety with the entirety in one application damage of any of the claim time after awarded it may be waived on using damage injury with known at the time of the claim. Damage claim and arising under the subchapter of the result of the prohibited discharge of the coastal wall with the recovery of the only manner provided with the subchapter of the being intent with the legislative of the remedies provided with the subchapter of the discharge of the coastal waters. Exclusive words of the funding of the damage of the claim with the not include the amount of the claim with the recovery of the account with the type of the damage waive the settlement of the responsible party, reasonable party with the representative of the judge of the current competent jurisdiction give the responsible party with the extent of the amounts of the duplicative. Have the claimant shall take with all the reasonable measure for the prevent with the minimum of the damage of the suffered of the claimant and resolve the discharge of the reasonable measures include the title search of the site assessment for the acquisition of commercial and industrial properties. Claimant to provide on the third party property party damage of the compensated with the subchapter that not include the damage for the not resolve of the prohibited discharge of the coastal water with the court awarding damage to the claimant that resolve of the discharge of the oil surface of water prohibited in section 543 such that the damages are awarded for the amount of the receipt of the funds for the extent of the amounts for the duplicate. H. Payment to the firm of the fund for the third-party damage claim with the domain act exceed $200,000 per claimant except the damages of the result of the discharge of the coastal wall with the when the claimant is publicly owned with the operative of the public water system. Third-party damage of the damage of real estate may not include the deal of the devaluation of the real estate associated with the loss of the water supply of the commissioner fined under Section 548 and 568. Subsection 2, public and private water supply with available water supply best meets with the criteria of the section of the property owner with not agree with the be served with the public and private water with the supply with the water supply with the wells installed with the after the October 1st, 1994. Serve a location immediately before the installation serve with a viable community public water system of the well is then become contaminated with the oil. Third party may not recover the damage of another subject at the expense of the incurred for the treating and the replacing the well of the well that is installed with the delineated the contaminated provided in subsection 548 subsection 1. 2. With the third party damage claim under the subchapter that regard the treatment and replacement of the well with limited with the reimbursement expense for the installing of the well and the property abandonment of the well is installed within the area. For the purpose of the paragraph, viable community public water has the meaning in section 548. The claimant is not eligible to compensate for the under the subsection with the cost of the expense of the damage related with the discharge of the commissioner determines the claimant is responsible party of the prior of the forward claiming of the hearing and examine. Or on subsection 3A, the commissioner may recover the amount of the claimant to be finalized. 3. L. Third-party damages may not include the expenditure of the preparation, prosecution of the damage claim with respect to the legal fee of the real estate, appraisal fees, and when the commissioner may dismiss the third-party damage claim and untimely filing with the failure of the claimant that will provide information necessary to profit the claim within 60 days after the claimant will receive the written notice of the claim of the insufficient with the prosecution and ineligible to determine the commissioner of the paragraph J. Dismissal may be applied with the Superior Court in accordance with Title 5, Chapter 375, Subchapter 7. 2A. Exemption third-party damage of the two the claimant at content with the commissioner that becomes aware of the claimant under subsection 2 of the commissioner shall send a letter with a certified mail and inform the person third-party damage claim of the process of the subsection 2. The letter must not contain the telephone number of the contact person available to explain with the procedure, board action, arbitration. 3. With the determine the dispute with the third-party damage of the commissioner shall establish the dispute with the claim for the claim process capability within the department to hear the determine the claim with the file within the subject of the agreed upon with the claimant with the commissioner of the reasonable part of the heads joined with the interest of the independent here with the examiner appointed with the commissioner shall hear with the determinant of the third party damage repair claims party for the hearing with the commissioner of the claimant to be with the extent of the practical all claims arising with the validity of the common discharge of the be heard with the determined by the same hearing examiner. Hearings may be before the hearing examiner inform all the rules evidence applicable to the judicial proceeding of the not binding the hearing examiner may administer the oath may require the submission of the attendant for the testimony of the witness production of the book for the records of the evidence relative to the pertinent issue of the present of the hearing examiner with the determination. Determination made by the hearing with the examiner final with the determination subject to the justice of the Supreme Court with the only matter of the relative of the absolute of the discretion of the hearing with the examiner the party seeking to review the hearing of the examiner of the discretion of the file of the appeal of the Supreme Court 30 days with the detriment made by the hearing examiner must accord with the presumption regardless of the subsequent the reimbursement of the presumption is repeated with the responsible party. The commissioner still certified that the amount of the damage of any of the determination hearing examiner certified that the name of the treasurer of the state of the funding with the funded fund pursuant with the subsection of the fee with the assessment of the file transfer first transfer of the private listed with the subsequent oil terminal facilities listed license the person required with the register for the commissioner on subsection 554B who first transfer of the oil into the state of the fees must be paid with monthly with the base for the records of the certified of the commissioner license fee that must be paid with the department upon the receipt of the credit to be the fund. A1A the fee is a 30-cent per barrel of the unrefined crude oil, liquid asphalt, 7 cents per barrel of the number 6 fuel oil, 22% of the barrel of the number 2 fuel oil, kerosene, jet diesel fuel, other refined products, other products otherwise specified with the subsection excluding liquid asphalt, 41 cents per gallon of gasoline. Paragraph that does not apply with the weight for the oil transport of the shape of the motor vehicle with a valve license of the Department of Transportation waste oil pursuant to section 1319.0, subsection 1, paragraph C with the subject of the fees established in 1319.1, C, B, C, and the D with the person subject of the subsection may be available to the commissioner of the rights representative of the document related with the other person's transport with the transfer of the during the period of representation of the license and period. When the commissioner project of the fund base for the reach of the $18.5 million the provided with the 15-day with the note of the barrel fees from under the subsection with the suspend with the $18.5 million fund exceed with the except with the transfer fee with the receipt with the 15-day with the notice has not been issued with the following any suspension fee with the assessed with the subsection. The commissioner will provide with the 15 days of any of the notice of the license before reimposed. If the fund of the balance reduced to $6 million left for the cleanup of the response fund review board under section 56B with the made adopt the increase the fee for the imposed with the paragraph paragraph A1, over the up to 20% of the barrel of the gasoline and up to 10% of the barrel of the other petroleum products, unexpected unrefined crude oil, liquid, or asphalt. Number 6, fuel oil necessary to avoid shortfall of the fund of the clean oil, the response of the fund, review of the board of the emergency rule making procedure of the Title 5, Section 8054. This is to ensure the fee of the institute increase the institute with the avoid shortfall of any fees and adopt the pursuant of the paragraph terminate the fees imposed in paragraph A1. So apply the fund's balance to reach the $10 million. 4A, penalty of late payment fees. Fees assessed under subsection 4 over the department on the behalf of the last day of the month, immediately with the month on which it will transfer the first transfer of state license or registration with the pay for the fee of the days shall pay for the additional amount with $10,000 amount with assessed under subsection 4 of the department to waive the penalty for the good cause shown with the license registration. The good may include without limitation events that may be releasable. Anticipate events were not under control of the license of the registration. 4B, reimbursement of the fees imposed upon the transfer out of state of the person who would pay for the fee under the subsection 4 of paragraph A1, subparagraph 2, 3, and 4. Petroleum products exported from the state of the reimbursed for the department of the following with amounts of the presentation of the documentation payment of the transfer for the 4 cents per value, number 6.4 of the 19 cents per value, and the number 2, fuel oil, gasoline, kerosene, jet fuel, the diesel fuel, with other refined product, their product, and otherwise specified within the subsection excluding liquid asphalt within 38% of the per barrel gasoline. A fee paid straight on the transfer of the state eligible to reimburse subsection oil of the documentation transfer of the presented with the department in 12 months for the transfer. Disbursement of the fund money when the fund may be disbursed on the following purpose of the other administrative expense for the personal service equipment with the cost of the detrimental relief of the administrative enforcement subchapter 2B with the except of the total disbursement personal service does not exceed with the $7 million for a year. All costs including a limitation of personnel undertaking the oil spill response clean activity equipment expense involved with the removal of the oil, the abutment of the pollution implementation remedial measures that include the restoration water supply of the related to the discharge of the petroleum product of the products covered with the subchapter including a discharge oil storage facility not paid with the responsible party application with the coverage by the fund any all discharge of the interstate pipeline of discharges proven in subsection 543 sums allocated to the research and development in accordance with the section D with the payment of third-party claim with the award within accordance with the section but not paid with the responsible party applicable with the coverage of the fund payment of the third-party damage if they are paid with the owners of the order pursuant with the section 568A subsection C 6. Payment of the cost sharing with the independent hearing examiners, independent claim adjuster for the third-party damage of the payment of the cost insurance that share with the implemented the benefits of the fund. Each of the sums of the $50,000 each year that have been allocated with the legislature with the contingency base in accordance with section 555. The payment of costs damage assessment of specific bills on site study for the environmental impacts of the particular discharge prohibited in section 543 may be the adverse economic effect of the other subsequent to such allocation of the studies for the determinant necessary to be the commissioner. The payments of the cost of collection overdue, the reimbursement also costs associated with the board of an underground oil storage tank install does not exceed $100,000. Payment to them on the behalf of the applicant eligible to cover the funds of 568A subsection 1, expense for the deductible in section 568A subsection 2, and occurred Commissioner approved cleanup activity specified in agreement at 568A subsection 4L us. All costs of the associated with the cleanup of the response funds of the review board with not exceed with $200,000 must cost and ensure the office of state of the fire marshal will implement with the duties assigned with the state fire marshal within the chapter that exceed $150,000. Some of the up to $500,000 aimed over the retrofit of the repair and replace with the removal of the above ground oil storage tank facility of the commissioner determined the action necessary to debate with the imminent threats for the ground war of the restoration project of the public water supply with the sensitive geological area with including coastal inlands. Peninsula with the money available with the paragraph that may be disbursement of the department of the pay reasonable cost that incurred with the municipality and assisting with the department of the taking the action of the paragraph of money available the paragraph may be used with the department to the fund of the educational effort that incurred retrofit repair replacement removal of the above ground storage tank for the facility that may not be disbursed with the few funds for purpose of the paragraph until the department has presented a plan with the such a disbursement cleanup of the response fund review board money may not be disbursed under the funds until under this paragraph until the department has adopted written policy according to the Maine Administrative Procedure Act. 1. Criteria to determine those instances whose fund will show by the disbursement in the paragraph include criteria to determine the constitutive expense for the geological area, with the guidance for the insurer of the money, with the disbursement of the fund, with the paragraph that will be with the cost effective with the manner, with the consider the likelihood of the actual contamination, water supply, with the absent action, presume with the paragraph of the cost of the recommendation, with the stuff of the contamination, for the possibility of the owner of the above ground storage tank with the facility, with the retrofit, the repair, with the remove of the tank with the owners and expense, guideline payment to the municipality responsible for the ministry of the cost of the actually incurred with the municipality with the assisting of the department in taking actions, and with the paragraph of the means for the test for the eligibility disbursement for the funds of deductible adjustment in accordance with the final means for the person receiving the disbursement, 6 limited eligibility residence for the state. O is sum of up to $2 million annually with the distributed community action agency defined in the Title 22 for the Section 532.1, subsection 2 for the loan for the grants for the retrofit, the repair, for the replace, for the remove of the above ground with the underground storage channel with the tank for the associated with the pipe to the single family residence when they made the disbursement of the funds for the pursuing with the paragraph until the disbursement of the present of the plan of the such the disbursement of the cleanup of the response fund review board of the community action agency shall administer the fund in accordance with the proper program operating schedule including allocation form list of the Maine State Housing Other with the weaponization program. Some of the available the other paragraph that may be disbursed for the department they just pay reasonable cost that actually incur with the community agency within providing services upon or assume the paragraph of money should be disbursed for the fall over the paragraph under the department adopt with the written policy for the corner for the Maine administrative of the procedure establishing guideline for the payment of the community agency with a reasonable administrative cost actually incurred by a community action agency providing services to pursue the paragraph this paragraph and sums up the $250,000 annual loans grant the department approved the rebate program the retrofit repair replace remove the underground above ground oil storage tanks associated with the piping of residential dwellings. Alright, 6. Reimbursement of the main ground surface of water cleanup and responsible for the money for the use of the fund for the commissioner shall seek with the recover the disbursements fund with the fund the purpose of include the overdraft of the interest imputed to 15% of the year of the day with the expense for the department of the fund with the amount involved with the small of the likelihood to success for the uncertain with the recover the cost of the unlikely to do with the inability of the responsible party with the pay with the cost of the expense to accept the recovery with the result of the damage of the to an oil pollution disaster declared by the governor pursuant to section 547 that must be a portion between the fund and the general fund to prepare the full cost of the general fund any of the bonds issued and a result of the disaster all of the disbursement may be funded with the pursuant with the subsection 5 of the paragraphs A, B, D, E, and H and I connection with the prohibited discharge. B. In case of the lieu licensed property reporting with the discharge required with the subchapter the disbursement made to the fund for the pursuant of subsection 5, paragraphs B, D, and E with the connection with the single of the prohibited discharge included with the third party claim in excess of the $15,000 except for the exchange with the cost coverage for the payment they received under the federal program. C, D, E with the disbursement may be found with a greater than $7.75 per occurrence for the expense to the fund pursuant to subsection 5 with the paragraph K with the applicant with the coverage of the fund with the fund found by the commissioner to be eligible under section 568A subsection 1 with the excluding occurrence for the underground storage oil facility. F. Disbursement made with a fund greater than $1 million with the occurrence of the underground soils facility expended with the fund with the pursuant of the subsection 5 of the paragraph K with the applicant with the coverage by the fund with the commissioner to be eligible to subsection 568A subsection 1 with the request of reimbursement of the fund not paid with 30 days with the demand with the payment determined with the attorney general for the collection may be sued with the collection agency agent with the attorney with the retained with the department approval of the attorney general in conformance with the Title 5 section 191 with the department to file the suit with the district court with the commissioner may file with the claims appropriate to the federal agency to recover the funds with the disbursement funds connection with the prohibited discharge. Request of the reimbursement of the fund disbursement pursuant to subsection 5 of the paragraph B with it may not be made with a 60 demand with the subject of the penalty with not exceed twice the total amount with the reimbursement request of the position and penalty the addition reimbursement request of the other fine with a civil penalty or with authorized title. Alright, 6A lien. All costs incurred with the tree of the removal of the abatement of the remediation prohibited discharge of the oil of the costs incurred with the tree of the abandonment of the ground oil storage facility with the tank under section 566A subsection 4. Interest of lien against the real estate with the responsible party line does not apply to the real estate license of the discharge caused with the structure of the carrier that is named the license facility with the responsible party determined eligible to cover the section 568A subsection 1. Lien amount with amount unpaid deductible assigned with subsection 568A subsection 2 eligible to clean up the third party claims above $250,000 to $1 million underground storage facility. Certificate of lien signed with the commissioner that may be sent with a certified mail with the responsible party of the meeting, recorded with the mail, filed with the officer of the clerk with the municipality with the real estate with the located with the lien, with effect with the certified with the required record with the registry, with a deed with the county with the real estate located with the certificate with the lien is included with the description of the real estate with the amount with the lien with the name of the owner as the grantor. When the amount of which the lien has recorded for the under subsection has been reduced, the commissioner upon the request any of the person recording holding an interest real estate with the subject for the lien with the shall issue the certificate of discharge, partially discharge the lien with the certificate must record with the registry with the lien recorded. Any action foreclose the lien may be brought with the attorney general with the name of the state of the superior court with the jurisdiction of the real estate that has been liened. Waiver reimbursement upon petition of any license of the board after hearing of the waiver of the reimbursements of the funds, fines for the occurrence for the result of any of the following in active war with the active government, state with the federal, municipal, except in so far as was pursuant to 548. Active God, which means unforeseeable, exclusively occasion with the violence nature of the interference with any human agency. Upon such finding with the board, immediately credit therefore that must be entered to the party involved the funds in the board conclusive of the legislative intent of the waiver provided with the subsection A of the privilege conferred with the not granted. Disbursement, state agency reimbursement funds incurred for the undertaking oil spill activities record demonstrate the amount of the spill response activity performed the reimbursement solved with the state agency itself to indicate the amount of the reimbursement for the fund with the disbursement fund state agency pursuant to subsection 5 paragraph 5 B must be deposited in the account. It should be established and maybe the agency support activities. And that was the Maine Groundwater Surface Water Response Fund. Oil Spill Advisory Committee repealed liability, and we'll cut the tape there to shorten it.